Chief Justice Roxanne George today ruled on the Misinga Jones versus GCOM case, calling Jones's application hopelessly flawed and meritless. The judge ruled that Jones and Attorney General Basil Williams misinterpreted what the Caribbean Court of Justice ruled. In fact, Justice George said that the CCJ plainly endorsed, rather than invalidated, the recount.
The AG submitted that Order 60 created a new regime, which is in tension with Article 177(2)(b) and Section 96 of the RPA, which provides for the CEO to ascertain the election's result by calculating the total number of valid votes cast from the declarations of the returning officers. The chairperson and the added respondents submitted that the CCJ did not invalidate Order 60. It is contended that when read as a whole, the CCJ decision confirmed Order 60. I have concluded that an holistic review of the CCJ judgment in Ali supports the contention for the chairperson and the added respondents that this issue is indeed res judicata. Thus, the interpretation of the CCJ decision by the applicant, the CEO, and the Attorney General is hopelessly flawed. The CCJ judgment lends to the ineluctable conclusion that the recount votes are ex facie valid. Hence, the view expressed that any irregularities would have to be addressed via an election petition.
According to Justice George, issues pertaining to Section 22 of the Election Laws Amendment Act and Order 60 of 2020 are res judicata, that is, already addressed by previous courts.
The answer to this question, in my view, poses little difficulty given the decision of the Court of Appeal in Moore. The Court of Appeal identified the constitutionality of Section 22 as an issue in the appeal. The Court of Appeal clearly held at paragraphs 106 and 107 that they agreed that the legality of Section 22 was a matter to be frontally examined by the court at a full hearing. The court considered the decisions of Petrie and Sikumar Singh and noted and held at paragraph 106 that the High Court declined to examine the constitutionality of election-related legislation during the election period, allocating such questions to an election petition. The court said that such a determination would be disruptive of the electoral process.
The Chief Justice also made it clear that GCOM Chief Elections Officer Keith Lowenfield is no lone ranger, but must take his direction from GCOM Chair, retired Justice Claudette Singh. She also read the CCJ judgment itself, which supports Section 18 of the Election Law Amendment Act and the subservient role that Lowenfield plays.
My conclusions as regards the interpretation of the CCJ decision regarding Order 60 necessarily mean that the answer to this issue is that the declarations of the returning officers as made pursuant to Section 84 have been overtaken by events whereby GCOM, in its wisdom, considered that there were difficulties that had to be addressed in order to produce what is termed in Order 60 as a credible count. In this regard, difficulties have arisen subsequent to the declarations made, and Order 60 was meant to address them, and in this regard cannot be said to have retrospective effect. As noted by the Court of Appeal at paragraph 109 of Moore, it is within GCOM's functions to resolve those controversies as part of its responsibilities to deliver results of the elections.
While Justice George emphasized the importance of lawyers not rehashing old cases repeatedly, Misinga Jones' lawyer, Roysdale Ford, has indicated an intention to appeal the ruling. Claudette Singh's lawyer, Kim Kite, committed to GCOM waiting for 1 day for the appeal to be filed. Charles Bryan, The Evening News.